Hello, everyone. I'm so glad that you're all here to join us. I'm so glad to see so many people taking an interest in this topic. My name is Persis Yu. I'm the Policy Director and Managing Counsel at the Student Borrower Protection Center. I want to thank you all for joining us today for our final event in the Beyond Fresh Start series. I hope that you've learned a lot through the last several panels. In the past few weeks, we've heard a lot about who defaults on student loans, who it harms the most, the harsh methods the federal government uses to punish those borrowers who fall behind. Just last week, we heard Undersecretary James Quall tell us there is really nothing good that comes out of student loan defaults except to debt collectors. All default does is drive borrowers who are already facing financial hardship into an even deeper hole. We've also heard and read some proposals that we hope the U.S. Department of Education will use as they are transitioning 7 million federal student loan borrowers out of default and as they start to draft new debt collection rules. But the reason why we're all here today is because we want to know, what role do states play in all of this? States, of course, hold a lot of power. They can, for example, determine how creditors use the courts. What rules must schools follow when collecting on past due amounts? How do we regulate the debt collectors themselves who are making so much money off of our defaulted student loan collection system? I'm so excited to bring you today's panel, which includes advocates, academics, legislative staffer, and a state regulator to help us dive into these issues deeper. But first, Suzanne Martindale is going to kick us off with some introductory remarks. Suzanne is the Senior Deputy Commissioner of Consumer Financial Protection at the California Department of Financial Protection and Innovation, where she is spearheading implementation of the new California Consumer Financial Protection Law included in Governor Gavin Newsom's 2020 and 2021 budget. She most recently served as Senior Policy Counsel and Western States Legislative Manager at Consumer Reports, where she worked for more than a decade on state and federal policy regarding banking and consumer credit. She's also a lecturer on student loan law at the University of California, Berkeley School of Law, and was a pro bono attorney at East Bay Community Law Center's Consumer Justice Clinic from 2015 to 2018. Suzanne, thank you so much for joining us today. I'm going to turn the floor over to you, and I hope everyone gets a kick out of what Suzanne's going to share with us. Thank you.
Thank you, Persis, and thank you everyone for attending. I'm happy to be here with you all this morning. My name is Suzanne Martindale, Senior Deputy Commissioner at the California Department of Financial Protection and Innovation. I know that's a mouthful. The takeaway is we are California's Consumer Financial Protection Agency, and we have placed a high priority at the department in focusing on people with student loans. For the obvious reasons, for the reasons that we're all here, right? It has long been, unfortunately, the second largest portfolio of consumer debt in the country after mortgages. It's almost unavoidable to take out some form of debt to pay for your education today, unless you happen to come from a very wealthy family. So many of us, I mean, myself included, have lived experience with student loans and know that it is a very confusing system. And when people call it broken, I have a hard time disagreeing, right? And so, what I want to cover today is what our department is doing, particularly now that we have expanded authority from recent legislation to do more to protect people in the space of consumer finance, student loans, debt collection, et cetera. And then generally how states are indeed today working with each other and with the federal government to leverage the moment that we are in, particularly while all the federal student loans are on pause, which is the bulk of the debt, to try to figure out how we can make some inroads to fix what has long been a system that has not worked for people with student loans. And we know that very well. So to get back to our department, if you haven't heard of us before, that's okay. Part of the reason is that we have a relatively new name. Our department has been a state banking regulator in one form or another in California over the decades and has gone through name changes and reorganizations and mergers and so forth. But we now have this name, Department of Financial Protection and Innovation. And we were given that new name, and along with it, expanded authority in 2020 because the governor and other stakeholders recognized that we were entering a time of great economic uncertainty due to the COVID-19 pandemic, a lot of financial stress to go around. And at the time, under the previous federal administration, that administration had demonstrated a lack of interest really in consumer protection. And I think there was a great level of concern that with so many people all at once on the brink of financial collapse, we needed an entity at the state level that could center the needs of consumers and communities and help to shore up their financial security, prevent predatory practices, right? While people were dealing with this unprecedented public health economic event in our country and around the world. And so the governor, working closely with the legislature, crafted this law, the California Consumer Financial Protection Law, that ensures that, broadly speaking, when companies are offering financial products and services out there, they have to deal with us. We have jurisdiction, right? And we're going to make sure that they're not doing anything unlawful, unfair, deceptive, or abusive when they are interacting with Californians. So this is a very, very powerful law. It's a new law. We're still standing up our new functions and training our staff to use it. But the upshot is it enables us to protect people who have historically not been protected, particularly in the areas of student loans and education financing. So how do we leverage our authorities? Well, we already had under a different law the ability to license and examine student loan servicers, but now we also are stepping up our game to increase oversight over debt collectors. Debt collectors were not historically an industry that our department regulated, but now we have clear authority to do so. I'll have to note that not only did we get this broad new financial protection authority from the law I mentioned, we also separately got a debt collection licensing law enacted. And so we are also using that. We are in the early stages of beginning to license debt collectors and debt buyers, who of course are part of the topic of the conversation here through this series of events, because debt collectors are of course going after borrowers. Although the folks that have federal student loans have gotten a bit of a reprieve thanks to the payment pause and the pause on collections, we know that people have private debts, privately held debts, and are not subject to those same protections. So debt collectors are still out there filing cases against people who have some form of privately held debt as a result of their education. So this is a very, very much a priority area for our department. Here are some examples of some actions that we have taken recently. We have issued subpoenas to about a dozen debt collectors to get more information about their practices. We've taken enforcement actions against companies that were violating our state's fair debt collection laws because they were engaging in aggressive debt collection practices that are actually illegal. And we have been very active there. We have also taken actions against companies that have been engaging in kind of debt relief services, making false promises to people about how to manage their student loans and the amount of money they can save if they use a debt relief service. And we are continuing to increase oversight over companies that are offering private forms of financing to students, things like income share agreements and retail installment contracts, which you may or may not have heard of, but these are private alternative instruments that people are being marketed to pay for educational programs, particularly career and vocational programs. And we want to make sure that those folks who take on those kinds of financing have the same kinds of protections and oversight that traditional federal student loans have already kind of had for a while, albeit imperfectly. So that's a little bit about what our department is doing. Again, we are in the early stages of standing up and implementing these expanded authorities, but I think you're going to see a lot more from us as we continue our work to protect students and people with student loans and repayment. And we are actually launching an expanded outreach and education campaign to spread the word about who we are and what we do as a department, because we want to make sure that every Californian knows that the DFPI is a resource. And so after I give my remarks, I will make sure to provide links to our website so that you have a better, so that you just know where to go if you want to learn a little bit more about what we do or get in contact with us. So now what are we doing? We're not alone. We're just California. We're a big state, but we're not the only game in town. What are we doing to coordinate with other states and the federal government to leverage our collective strengths as government partners to help fix the broken student loan system? Well, we're doing a lot. I mean, the good news is, and I see Martha on the call here, she and I are involved in regular meetings, multi-state meetings, also meeting directly with the U.S. Department of Education, because I can't overstate the importance of just sharing information, of talking regularly, of making sure that we are flagging, here's what we're seeing, here are common complaints we are getting from people with student loans, so that they're hearing directly from us what kinds of problems are seeming to be priority systemic so that the Department of Education can be prioritizing what they're thinking about doing as they're leveraging their tools administratively to provide additional relief to people around the country. So when we have problems about, for example, there's still a lot of misinformation that borrowers unfortunately are getting from loan servicers and debt collectors about what their rights are, about what current debt relief efforts are available to them. We are constantly hearing about those. And so we always want to flag those for our government partners at the US Department of Education. I mean, the good news is, although yes, many things about the system are broken, at least we have the payment pause in place to give everyone in government room to think for a minute, to stop and say, okay, here are all the operational challenges that are out there, but at least while the student loans are at the federal level are on pause, now what can we do? What can we tweak here or there? And that's some of those conversations that we've had have resulted in the department rolling out some of the recent initiatives that they have rolled out, whether it's related to correcting payment counts for the purposes of public service loan forgiveness or income-driven repayment, the Fresh Start initiative. All of these initiatives have really been enabled by having the payment pause in place so that everyone has an opportunity to sit down, take a look at these historic, long-standing structural problems that we've all had, that advocates and academics and regular folks, individual student borrowers have flagged for the government over the years. And now they've actually had the room and the ability to leverage their time and resources to roll these things out. And actually, we just saw this morning that they are going to finally cancel those longstanding debts that students have held from ITT, right? Another one of those failed troubled for-profit colleges, just like Corinthian. So, we're making progress, but of course, there is much more to do. The meetings that we're having with government partners, are going to be ongoing. And as we share information and resources, that helps inform all of our policy priorities going forward. And so, to get back a little bit to what DFPI is doing, we are improving and consistently upping our game on outreach, education, consumer and inquiry complaint handling. We also have recently hired a student loan ombudsperson. Several states have them. We now have an ombudsperson, Selena Damian, who attends events like this, who does webinars, who educates, local jurisdictions. She goes to school districts, she goes to nonprofits, she goes to, to every level of government to make sure that she can serve as well as a point of contact. And she handles, inquiries from people who just want to understand how to even understand and manage their loans and what their status is and what they can do. We are very cognizant of the fact that there is a lot of mistrust out there. People have been burned by the federal government, by loan servicers, and don't really know if they can trust the information they get from the federal government. And so we want to become that trusted resource at the state level to make sure that people can get an honest answer from us, and that we can provide them just basic plain language information. And again, via our ombudsperson, someone who will actually be a human being who will listen, because we know that sometimes that's just the first hurdle toward people who have these student loans, who are stressed out by them, just being able to level set and feel like there is hope, that there is an ability to manage these loans and get out from under them, because this is a situation that takes real personal psychological toll on people as well as a financial toll. We know that the burdens around student debt, the onerous collection authorities that certainly the government has when they collect on a federal student loan, the limited bankruptcy rights that people have really contribute to a perfect storm where people just don't have the level of rights they should have when you compare student loans to other forms of consumer debt in this country. So what I will say, I think the main takeaway and my invitation to you all is please, speak up, file complaints and inquiries. We think it's really important that these kinds of events, whether it's the Student Borrower Protection Center hosting them, or we host some as well, are very important. This kind of ongoing communication and collaboration, there really is no substitute for it. Because I'll tell you, as Claire Johnson Raba's paper flags, there's a lot that states can do in terms of legislating and passing reforms, and it's great. And as her paper demonstrates, California actually has already done a lot, whether it is court reform, whether it is limitations on things like, for example, bank levies, which can impact people post judgment when debt collectors can freeze people's bank accounts. The legislature has done a lot of good work on those kinds of initiatives. Also, of course, the legislature has given us expanded authority, which is great. But at the end of the day, and I am seeing this now from the inside, now that I am a regulator, I used to be an advocate lobbying for those very pieces of legislation, and now I'm in government. I'm finding that personnel is policy. And these laws are just words on a page, unless you have people, dedicated public servants who are going to do the hard work over many months and years to implement and enforce these laws. And we do everything we can to be proactive, in part by attending events like this, of course, by fielding complaints and inquiries, by having stakeholder meetings on a very regular basis, but certainly don't wait for us to come to you. Please do get in contact with us, file complaints. There are ways you can sign up to our email subscription services to get information about what we're doing. And in fact, on debt collection, we have an open rulemaking right now related to debt collection. We're taking comments about who stakeholders believe we should be requiring to get a debt collector's license with us. That comment period closes on August 29th. I will put a link to that in the chat after I'm done speaking to make sure you all have access to that. We really need input about where the problem areas are, the kinds of common complaints you're seeing, because we need to flag that. Not only when we're writing a rule or maybe thinking about opening a case, but so that we're training our staff. Keep in mind that for financial regulators, a lot of our staffers who are supervising companies like debt collectors, they're examiners. Their background is in accounting or in finance. They may not have the background in law and policy that comes naturally to those of us who have learned these issues through that kind of skill set. So it's on us to make sure that we are training our staff to understand what does it look like for a debt collector to be acting unlawfully, unfairly, deceptively, abusively, et cetera. And so these kinds of convenings, the kind of research that the Student Borrower Protection Center is producing is fantastic. But for any of you who are organizations that want to present any research you're doing, if you are a legal aid organization who has clients and you want to share stories, we are an open door. We want to be very accessible to all of you who are external stakeholders who really care about the intersections of student loan debt and debt collection in this space, because we want to be armed with the most robust information possible to ensure that as a regulator, we are targeting the riskiest behavior and we are allocating those resources that we have through supervision, through regulations and enforcement to ensure that we are cleaning up the mess wherever we can. We want to leverage every single tool that we have at our disposal as a regulator, on our own, getting input from you all, working with our government partners at the state and federal level. There is an endless need, an endless demand for help. People need help in this space, and we are acutely aware of that. But we, this is very hard work. But I think when we work together and leverage our collective knowledge and experiences and resources, we can do a lot. It feels like an uphill climb sometimes these days. And given that particularly post default, the debt can really be stacked against people with student loans, and it's very troubling. That said, it's a challenge that's worth taking on. And at the end of the day, I certainly find the work rewarding because I get to do it, and the department gets to do it with all of you. So please consider yourself a partner in this work and do not hesitate to reach out to us as we continue to clean up the broken student loan debt collection system. Thank you so much for the opportunity to speak to you all today.
Thank you so much, Suzanne. It was really wonderful to hear from you, to hear these words. Most importantly, thank you so much for the work that you are doing to protect student loan borrowers in California. Hearing this gives me a lot more faith into what we can do next when we are looking at Beyond Fresh Start. And I hope everyone took note of those comments that are due in October for the debt collection rules, and we'll be passing out the resources that Suzanne shared with you momentarily. So now I want to turn to our panel, because we have a really dynamic conversation lined up for you with some really phenomenal experts. One thing I do want to mention is that this is meant to be somewhat interactive. Please put your questions in the Q&A function. We have some dedicated time at the end, but if we're able to integrate them into the conversation, we might do that too. But let me first turn it over to Meredith Kolodner of the Hechinger Report, who is going to be facilitating this conversation. Meredith writes investigative articles and produces data analyses for higher education and K through 12 stories. In particular, relevantly for us, she's written extensively on collection by colleges and the impact of unpaid tuition and fees. She previously covered schools for the New York Daily News and was an editor at Inside Schools and the Investigative Fund. She also covers housing, schools, and local government for the Press of Atlantic City and the Chief Leader newspaper. So Meredith, thank you so much for taking on this facilitation role, and take it away.
Thank you, Persis. Thank you for having me. And thank you to the Student Borrower Protection Center for putting this panel together. It is touching on issues that are so important to so many students that fly under the radar a little bit in a way federal student loans don't. But are equally important and equally as impactful on students' lives. I'm going to start by just asking the panel to introduce themselves, and then I'll ask some questions, and then, as Persis said, we'll have time for questions from the audience. So, Jith, do you want to start? Just introduce yourself and say a little bit about your work.
Sure. My name is Jith Meganathan, and I am staff counsel at the California Assembly Judiciary Committee, where issues relating to student loans and debt collection are among the issue areas that I cover. I was a longtime legal aid attorney and had many clients facing both debt collection issues and student loan issues. This was from 2007 to 2012, so predating the CFPB and a number of the legislative reforms that Suzanne alluded to. Probably most relevant for our discussion today, in 2021, the chairman of my committee, Mark Stone, authored a bill that was sponsored by Student Borrower Protection Center, and I staffed the bill to greatly strengthen the evidentiary requirements around collection of private student loans. I'm happy to speak more about that.
Okay, great. Thank you. Kat, do you want to go ahead?
And I'm so happy to be here today. Hi, everyone. I'm Kat Welbeck, Advocacy Director and Civil Rights Counsel here at the Student Borrower Protection Center. I won't do too much background because Persis did a wonderful job in the intro talking about what we do here at the SBPC. But prior to joining the team, I worked at the CFPB and our External Affairs Division, but really excited today to talk a little bit more about some of the work that we've been doing in states, and then also talk about how that also intersects with the way that we look at the student debt crisis as a civil rights crisis. So the intersection of those two. So excited to join this panel today.
Thank you, Kat. Martha, do you want to introduce yourself?
Thanks so much, Meredith. My name is Martha Fulford. I am a First Assistant Attorney General here in the Colorado Attorney General's office. I'm also the administrator of our Consumer Credit Unit. So in Colorado, we do things a little bit differently than in some other states. We have a lot of our regulatory function, particularly over non-depository, so non-bank entities housed in our AG's office. So we regulate student loan servicers, private education lenders, collection agencies, certain non-depository lenders, debt management providers, and non-bank mortgage servicers in my office. So we see them both from the regulatory and supervisory side and from the enforcement perspective. So really happy to be here, and I will just give my standard government disclaimer, which I'm sure you all have heard before. The views that I will give today are my own views, are do not represent those of the Attorney General, and none of what I say today constitutes legal advice. So thank you very much.
Great, thank you, Martha. And Claire, if you could introduce yourself and maybe also give a little introduction to the paper that you wrote that Suzanne mentioned in her remarks.
Thank you so much, Meredith, and thank you everyone for having me here today, and thanks to the SBPC. So my name is Claire Johnson Raba. I'm currently an assistant professor of law at the University of Illinois at Chicago. And similar to what Martha said, my views are my own and they do not reflect endorsement of any position or legislation by the University of Illinois, Chicago. So I, like Jith, I was a legal aid attorney for about 9 years. I ran the consumer law unit at the Bay Area Legal Aid. which serves 7 counties in the San Francisco Bay Area. And we dealt with so many clients who had consumer law issues and student loan issues. Student loan issues were prevalent throughout sort of all of our practice areas, and we received referrals from all of our practice areas for folks, seniors, co-signers, and all sorts of folks who are dealing with student loan debt. It really does run the gamut of affecting everyone. I'm here to talk today a little bit about a paper that I wrote. It's one of 6 papers for the Beyond Fresh Start convening series, all of which are fabulous, and you should check them out if you have the opportunity in the SBPC website. And the paper that I wrote analyzes private student loan lawsuits in the state of California for about 12 years. So I did a deep dive into court record data to see what the court records themselves could tell us about sort of the long legacy and the long impact of private student loan lawsuits. And so I'll talk a little bit more about that if in the back and forth for the panel, Meredith. But sort of as a bit of an introduction, it's basically a deep dive into what the courts can tell us about the long tail and the impact of debt collection lawsuits and the judgments that are often entered against borrowers who can't afford to pay their student loans.
Great, thank you. So to kick it off, if you all could address the question of what are sort of the basic problems that are embedded in state debt collection? What really causes problems for borrowers, and why does it even really matter for folks who might not be as acquainted with the subject of state debt collection? And Claire, why don't you start? We'll go in reverse order.
Right. So private student loans differ from federal student loans in a number of ways. I mean, private student loans are not a whole lot different from, a credit card that you might borrow or an installment loan that you might take out, to purchase something for your home. And so private student loan debt collectors can actually sue in court and use the court systems to collect. Federal student loans have a number of, deferments, forbearances, and income-based repayment programs and things like that that borrowers can avail themselves of. Federal student loans also have things like disability discharges built in because that's by statute and regulation. However, private student loans don't have any of those forms of relief. And really, it's a bit of the Wild West out there that you've got private student loan debt collectors who can go into the court system and file a lawsuit, often without a lot of proof or evidence that they own the debt or that the borrower is actually liable to them. And then they move through the court process. And my research has shown that, between 95 to 98% of student loan defendants in California are unrepresented by an attorney. And so that really allows the student loan debt collector to use the processes of the court system, which they and their lawyers are very familiar with. And so it really is a volume business model for the private student loan debt collectors where they move through the courts and they really rely on borrowers being scared and defaulting, meaning that they don't respond at all. If somebody doesn't respond to a debt collection lawsuit or they show up in court and they're not sure how to manage the processes, then that means a judgment gets entered against them. And a judgment collects interest. And in California, judgments exist for 10 years and then are renewable for another 10 and another 10 and another 10. And the whole time they're accruing interest in California at a rate of 10% per year. So I noticed somebody put in the QA, does this apply to other states as well? And so debt collection processes vary, from state court to state court. But in general, that's the process. If somebody defaults on a contractual obligation, then a creditor can bring a lawsuit against them in court. And it's pretty well known, the Pew Charitable Trust, the SBPC, the CFPB have pointed out recently the ways in which creditors and creditor attorneys use court systems to basically rubber stamp these judgments against consumers. And the research shows that that's very prevalent with the private student loan debt collections as well, that very few people have the opportunity to assert any defenses.
Kat, do you want to follow up on that at all?
Certainly. And one thing I want to touch on, I think Claire did such a wonderful job talking about the differences between, private student loans and the fact that they have significantly less protections than federal student loans. But I also want to talk about another type of debt that many student loan borrowers hold that we'll probably talk a little bit more about today, and really talking about institutional debt, which are not necessarily loans, but thinking about rather, fines and fees and debts that students owe to schools, and eventually end up resulting in things like diploma holds, transcript withholding, holds on registration and re-enrollment, and just really the ways that these kind of debts also create double binds where students are one, still subject to collection, but then two, also are either not able to complete their education because they can't re-register because of these holds. They're not necessarily able to get gainful employment because they can't prove necessarily that they have the diploma or necessarily use a transcript for employment. And so really also talking about how these type of debts also really drive inequitable outcomes in our student loan system. And when we're thinking broadly about collections, and also again, talking about the ways of the student debt crisis. I know we talk a lot about the ways when we look in communities of color, particularly those that are Black and Latino, and how the student debt crisis, disproportionately affects communities of color. Also looking at the way that these type of collection practices also, again, disproportionately affect low income and Black and Latino consumers. But also really excited to talk through the rest of this panel, thinking about ways that also states are really stepping in, schools are really stepping in to change these practices. So I'm gonna kind of start with like the bad, but also I know we're gonna lean into a little bit of ways that states are improving these practices later.
Sure, thank you. Martha, do you want to talk maybe a little bit from your perspective of what this looks like where you're at, or you can also speak more generally to the problem?
Sure. I mean, I would really echo Suzanne's comments in terms of individuals who are experiencing issues with their student loans or with collections, that your state attorney general's office in California, also their Department of Financial Protection and Innovation, but for all consumers, their state attorney general's office and the Consumer Financial Protection Bureau are places where consumers can and should complain. I'll quote the former director of the CFPB, Rich Cordray, by saying, those are the canaries in the coal mine for us. And in our work, especially at the state level, hearing from consumers about the experiences that they're having and understanding the problems and how those affect, the knock-on effects that they have on consumers' lives, that drives our work. And so the importance of I can't emphasize enough the importance of those consumer complaints and hearing from consumers about what it is that they're experiencing. I would just say also Colorado, like California, is one of the states that has the student loan ombudsperson. And we have a whole team who are dedicated to helping student loan borrowers navigate the student loan repayment process. And I know Persis noted in one of the prior sessions that there are legal services organizations that need funding as well. I don't view this as a substitute for that, but that it's really complementary to a system and hopefully an additional resource for borrowers to reach out in states that have them to these student loan ombudspersons or advocates to help them navigate this process.
And before moving on to Jith, can you say a little bit more about how you've seen the problem affect consumers' lives? Like what does it really look like for people who are facing these sorts of debt collection or anything that's sort of come through your office? Yeah,
I mean, as I think the other panels have articulated so well, student loan debt really it affects all aspects of a consumer's life, and we see it affecting even entire communities. There are particular communities who have been targeted, in particular by certain for-profit schools that Kat was referencing, and we see that have a knock-on effect on those communities' ability to have financial resilience and to build wealth. And so the sorts of collections activities that happen on federal student loans are the prior panels have talked about the power that the federal government has, but even on the private collections, it can have devastating effects on consumers when they're not able to build wealth or to effectively navigate the repayment process. So we see that every day in complaints, and it certainly drives our work on how we consider our resources in terms of enforcement resources and supervisory resources, what we're going to devote them to.
Jith, did you want to chime in?
Yeah, absolutely. And I should echo what Martha said earlier and say that the views that I express here are solely my own and not those of the California legislature or any particular legislator. So the areas in which we have heard the most complaints and in which we've been able to act given our legal authority in California are, one, servicer issues. So people finding out exactly how much they owe, what payment history they've been credited with, how to correct mistakes. Folks like veterans who may be getting some sort of subsidy due to their service on their loans, like making sure that those are accurately credited. So there's servicer issues. And then on the collection side, which I realize is the focus here, really building on research that Claire did, what we saw were markedly different outcomes when borrowers were represented by attorneys. Borrowers represented by attorneys virtually never lose a collection case in court. And that's simply because the evidentiary foundations tend to be so weak on many of these cases. Debts have been sold repeatedly, payments haven't been credited. Sometimes you can't even prove, or the debt collector can't even prove that the loan was originated. And what really concerned us at the Judiciary Committee and as a matter of policy is that there shouldn't be such huge discrepancies between the outcome of a case if you're represented by a lawyer and if you're not, particularly, as Claire said, when between 90 and 95% of borrowers aren't represented.
Interesting. Okay. Kat, do you want to answer that question that came through about webinars or workshops or just general information that about products or practices that target communities of color?
Certainly. And so I'm sorry, I'm like looking.
Sorry, there was, yeah.
And so one thing that we at the SBPC, we host regular webinars right now specifically targeted to the PSLF waiver. And so one thing that we do, these are workshops, targeted to like some time limited changes to the public service loan forgiveness program. But I think I want to touch on something that Suzanne mentioned earlier in her remarks and talking about the importance of state ombuds. So if you do live in a state that has a student loan ombuds, and also like Martha mentioned, you have an amazing resource there to be able to contact someone who can, one, either guide you through these process, answer these questions, or even like give you more information. And I know, again, we're going to talk about, again, the importance of having, borrower bill of rights and how much these are literally changed the lives of borrowers who live in states where they have not only these laws, but they have resources in their state, their student loan ombuds people. So if you do live in a state, if you can maybe drop your state in the chat, we could figure out if you do have those resources where you live. So again, I'm just going to do another really, really huge plug for the importance of student loan ombuds in those states and really being able to provide resources to student loan borrowers.
And before we move on to some of that, if what is the sort of scope of this problem? Can anyone, I know there's not proper data, but can someone say how broad and wide do you think it affects students, borrowers, people in your state? Any sense of how many people are being hit by this or how big of a problem it is, even if there's not specific numbers? And anyone can jump in.
Well, at least with private student loans, we know that like even in California alone, there are about 600,000 people who hold private student loans, and that's either in addition to or in lieu of federal student loans. However, our records, their search and the data on the California court records show that not that many people have been sued on them. We've had about 15,000 lawsuits. And so that's a lot of lawsuits that are potentially still out there pending and could be filed. I do know sort of anecdotally and from my work in legal aid that servicers of private student loans often will place people into deferments and forbearances and require them to pay a $50 sort of administrative charge every year. And just like other debt collection loans that are in default, every payment resets what's called the statute of limitations. So a creditor is only allowed to sue you for a certain period of time after you stop paying on a debt. And that period of time differs by state law. I mean, it might be 4, 6, 10 years. But every time you make a payment, it resets that clock. So folks that are out there with old private student loans that they haven't been paying, that are still accruing interest, every small little payment that's made does reset the debt and does give the creditor a reset button on their time to sue you. So you might say, oh my gosh, I have these old student loans that, they've been in default for like 10 years. But every time you do make a small payment on those, it does reset those. So I believe, with private student loans and debt collection in the state courts, it's an issue that's still looming out there because there are a lot of the disconnect between the number of lawsuits that have been filed and the number of loans we know that were originated means that there are a number of people out there who have not yet even been sued on private student loans that are still carrying that burden.
And how aggressive are the debt collection agencies being right now, given that there's the pause on the federal student loan collection? Do you see a similar pause by debt collection agencies, or is it operating in a parallel universe? And anyone can jump in.
We do know that debt collectors generally, broadly writ, during the pandemic were actually two of the largest third-party debt collection companies saw record quarters in the first quarter of 2020 when people were receiving their pandemic stimulus. And if you have any sort of defaulted debt or are suffering economically, you might notice that there are ads that might follow you around the internet that say, hey, we'll take payments of $5 a month. Midland Funding and Portfolio Recovery Associates will target people with targeted advertisements, saying, well, you might be flush with a little bit of extra cash. Now is the time to pay off your old debts. So perhaps not specific to the private student loans alone, but I know that debt collectors are certainly seeing a boon in their collection activity during the pandemic time and targeting borrowers, trying to get borrowers to settle out or resolve old outstanding debts.
Okay.
Well, in Colorado, our legislature extended allowed for borrowers to raise a hand to say that they were suffering a COVID hardship for a period of time to limit any extraordinary collections actions. That lasted, I think, for maybe 4 or 5 months, and then they gave our office authority to extend it based on an order. So we took comments. And then extended it for several more months. And then when the legislature came back into session in 2021, they then extended it. That expired, I believe, in June 2021. And so those sorts of pandemic specific, I think that's probably roughly consistent with other states' experiences that had pandemic specific, protections on collections. Those have largely, I think, expired. But we certainly had those in Colorado for some period of time.
Okay. Well, so maybe that sort of gets us into the next question, which is, to the extent that state debt collection should continue, how do you make it more humane, more fair in any way? Or do you think that actually there's no way to make it more fair and it should just stop happening? And Jith, why don't we start with you?
So I'm going to reserve any opinion on whether there should be collection of student debts. But given that there is, the way that we have addressed this problem in California is essentially outlining all of the evidence that a competent attorney would require a debt collector to produce in a collection lawsuit. So proof of origination of the loan, chain of title, like being able to prove assignment to every subsequent entity that claimed ownership, payment history, kind of an itemization of how they got from the original balance to the balance they're claiming is owed. So that has to now, under legislation that we passed in 2021, has to be provided to the debtor when collection first begins. And this information also has to be attached to any complaint for debt collection. And so we're hoping that that simply stops data collection that lacks this sort of basic evidence. And there's also in our statute, there's a private right of action if there is collection activity and this information is not provided to the consumer. So that's a further deterrent. It can also be enforced by Suzanne Martindale's agency, the Department of Financial Protection and Innovation, as well as public attorneys like the Attorney General. So that's been our main approach. But it's very new, so only time will tell what the actual effect is.
Kat, what about you? What do you think?
I will offer an opinion here. I think for me, I don't really ever think we should continue a punitive system that's targeting people when they're facing financial distress. And so, like, if anything, I think how can we use state resources to support people in their greatest times of need rather than thinking about ways to extract? But that's not fully the question. So I think for our other panelists have offered really wonderful interventions that would create meaningful change in our state debt collection system. So one, to the point that Jith was making, and also that Claire laid out so wonderfully in her paper, is thinking about court reform and court reform bills, and thinking about, again, the substantiation of records, like actually putting that evidentiary burden on collectors. And so really just reaffirming everything that Jith said there and that Claire outlined in her paper. But then also to the point that, again, Martha's talking about, and then thinking about the important role of, legislation like borrower bill of rights legislations that really increase protections for student loan borrowers, I think would also make the likelihood of default less likely, because, really giving borrowers more rights, putting greater accountability on the behalf of servicers to actually make sure that they're not taking advantage of borrowers. But then also, again, earlier, I know we're talking about institutional debt. So what's the role of schools? And again, also state legislators so either schools ending these practices because they're deeply punitive, or legislators ending these practices because they're deeply punitive and the schools won't take the steps they should be taking to end them. But then also, I also think there's some other interventions where we can think about ways to meet people in times of need. And so I know we've talked about this specifically at the SPPC when working with municipalities, but also thinking about ways that, even with states being able to, we have the data to know where there's the greatest level of distress for student loan borrowers, where there's the highest rates of delinquency, highest rates of default. Are there ways that we can catch this early, and thinking about how do we target places where we also have intervention for low-income borrowers where they know they might struggle? Are there ways that we can also pair with that interventions that we would have for borrowers who are struggling? But I really think, one, again, don't believe in a punitive system of debt collection. But again, if we are going to talk about ways to improve the system, I think there are some interventions that we can make.
Thank you. Yeah, Martha, do you want to?
Sure, I'll just jump in and really echoing Jith and Kat's points, just to emphasize in Colorado, we had similar legislation as in California relating to requirements on collections actions and documentation. Within that same legislation, we established a private education lender registry and had substantive requirements placed on our private education lenders relating to things like cosigner release and total and permanent disability discharge. So there are opportunities at the state level for instituting certain kinds of protections that I think will help borrowers. We also, in the most recent legislative session, changed our exemptions for garnishment and levy, which hadn't been revised in quite a while. And we were, prior to those amendments, we earned a D in Colorado from the National Consumer Law Center for our protections. I don't know that this quite brings us up to an A, but nobody wants to be a D. And so our office was supportive of that legislative effort to protect things like housing everywhere, but in Colorado in particular is very expensive, and the homestead exemption had not been increased in quite a while, offering protections, broadening the definition of what counts as a home to include tiny homes and things like that. So trying to really reflect the lived experiences of consumers in our state. And that was, a really important effort. We also, in this most recent session, passed a transcript diploma withholding bill. And our office is available to receive complaints on those issues. So I'll be sure to put our office's information in that chat for Colorado consumers. But there are really important legislative efforts that have happened in Colorado, and I think we are happy to be as a part of a group of states, an ever-growing group of states who have passed things like the Student Borrower Bill of Rights. And as Suzanne mentioned, we get together, we share best practices, we think about trends that we're seeing across the states, and really can hopefully be a force multiplier in this area to help borrowers across the states and advocate on behalf of borrowers for the federal government. I'll just say, I think it's really important to be entrenching these kinds of protections in state law at this time. It's a wonderful thing to have great federal partners right now. And as Suzanne mentioned, we are working with the Federal Department of Education. We're having regular meetings with them. We're sharing information with them, which is an all new experience. But state government and state agencies like the Colorado Attorney General's office, like DFPI, like those that exist in other states, are going to be doing this work now and in the future. And we can't always trust that there will be people responding in the federal government in the way that we might hope. And there's still a lot of work that we have, even with a federal government, a Department of Education who's very willing to be making changes, but they have a lot of work to do. States can continue to push for those changes, and states are going to be doing that work on an ongoing basis, no matter who's in power in DC.
Claire, I'd love to give you a chance to answer this, but I will add in there it sounds like a lot of the possible solutions are legal in nature. And if one of the problems is that most people either currently and probably in the near future will not have legal representation, are there other moves that can be made that would help people who are in this situation?
I mean, I think that's a really excellent question. As a former legal aid attorney, I know that the justice gap is real, that we don't have, anywhere near the number of legal aid attorneys or free representation. And then there are all the people who fall in the gap. They might not qualify for legal aid services because they're not quite low income enough, but yet they're certainly not in a position to hire a private attorney to represent them. I do think there are a lot of interesting things afoot for unrepresented litigants, both like in state and in federal court. There are sort of software solutions that help people file their own bankruptcy. I'm not sure if those software solutions go quite so far as to help you file what's called an adversary proceeding, which you need to file in order to seek a discharge of your student loans. But there are folks that are working sort of in the technology space, in the digital services space, in mobile friendly apps and things like that are helping people to advise people of their rights, chatbots and things like that. So sort of using technology to scale some of the limited resources that we have in legal aid and at the SBPC and things like that. I know the SBPC has done a wonderful job leveraging sort of social media in its time in existence to reach as many borrowers as possible, to spread the news and sort of know your rights information. So while I think everyone having an attorney is not necessarily attainable, I do think, more people knowing about their rights and knowing about important bills like the Borrower's Bill of Rights in Colorado or AB 424 in California, which strengthens the evidentiary requirements. So I do think that organizations like the SBPC and the state enforcement agencies go a really long way towards helping people to understand and assert their rights when they're unrepresented.
Are there any efforts to do things like cap interest rates or do anything that would just simply bring down the amount that a borrower ends up owing? Yeah, go ahead.
So I'll speak to that. So New York actually just passed a bill last year dropping the interest rate from 9% to 2% on consumer debts, including private student loans. And it's retroactive. So it means all of these judgments that sit out there accruing interest. The New York bill effectively reduced those interest rates or attempted to reduce those interest rates from 9% to 2%. And unfortunately, that bill bill has been put on hold. A group of credit unions brought a lawsuit in district court in New York challenging that under the Constitution. Basically, they said this is a governmental taking of the interest that we're entitled to, that we have already accrued. So I do think that as we look to legislative reform at the state level, it's going to be difficult to knock down the interest rate on existing judgments. And so a couple of the points that going forward, absolutely 100%, interest rates should be reduced to zero or to very, very small amounts, particularly on these private student loans, given that they had such high interest rates and accrued such high balances before folks got sued. But I do think a couple of the things that I proposed in the paper that I wrote for this series is that judgment should not be renewable. People should be entitled to a fresh start. So if you're sued on a debt and there's a judgment entered in the court, in California, as in many other states, the creditor can come in and renew that and make it enforceable again. So they can go out and garnish your wages or levy your bank account or put a lien on your property indefinitely. And so if we just put a halt on that and said you could only you could not renew a judgment, and once it expired, that means that the people who are carrying around all these old, like National Collegiate Student Loan Trust judgments, which was basically a trust entity that held a large number of private student loans. We know that actor has engaged in a lot of unfair behavior, deceptive behavior, sort of a lot of the things that Suzanne Martindale was talking about earlier. We know they engaged in robo-signing. There were cases against this entity by the Massachusetts AG, by the New York AG, by the Consumer Financial Protection Bureau, yet there are still tens of thousands or hundreds of thousands of these National Collegiate Student Loan Trust judgments sitting out there and that are still collectible. So one of the great things that states could do is they could exempt from wage garnishment. They could exempt from bank levy, private student loan debts that are so old. That means that if somebody had the means to pay for them, they could pay for them, but that it would be considered, against public policy to take money out of people's paychecks to pay for these private student loan judgments. So those are some of the steps that we could take going forward. Unfortunately, reducing the interest on old judgments is unlikely to survive this sort of constitutional challenge. But I think there are a lot of other ways that states can ensure that people get a fresh start by halting the collection arm of the court as when it comes to private student loan debts.
I know there was a question about older borrowers, seniors and older borrowers, and I wondered if you all would address some of the issues that specifically face seniors or just older borrowers in general, and what can be done to help that group of people. And how about Kat?
I was like, I know who wanted to start. I think that's something that's already been mentioned a lot today, and we've been talking about borrower bill of rights, and I think that they're really important protections in many of those bills that protect older borrowers, particularly those that may have co-signed on loans for either their children, their grandchildren, and really being able to create additional protections for them in those. But also talking about the importance of how we actually have so many older borrowers. We often think about, or a lot of times people describe the student debt crisis or think about the student debt crisis as something that just affects younger people, but really thinking about when we talk about creating these broad-based protections, it's also helping to protect a lot of our older borrowers, particularly as we think about people aging into their student debt. So people who might be on, limited income, people, hopefully getting closer to retirement, but also being afraid that they can't retire because they have the student loan debt. And then also one thing I would be remiss if I didn't mention is also thinking about, I know we're talking about states, but also changes that are happening within the federal program, and thinking about older borrowers who may have older legacy loans like FFEL loans, thinking about the fact that there are some programs, like for example, the IDR account adjustment, where the Department of Education is reviewing accounts and seeing if people are eligible for cancellation after 20 or 25 years in repayment based on, which IDR plan they're in. But one thing that we realize is a lot of people don't even know about this. And so also one, I think, significant gap is also being able to get information to people who could actually be who could be free from their debt, and finding out ways to make sure that people aren't indebted longer than they need to be. And so one, again, is just repeating, a lot of this is just about these protections help older borrowers, because we have a significant portion of borrowers who are older adults. But then two, how do we make sure that people know about the programs that are available to them, or access to debt relief that they might know? And again, I do want to do a shout out to our states that do have ombuds who are sharing this information, but there's still a lot more, millions of borrowers who may not necessarily know that they have access to relief.
Jith or Martha, did you want to chime in on this at all? If not, it's okay, but. No, good. Claire, no, I can move on.
Well, I will say that for private student loans in particular, cosigners are a huge problem. When I was in legal aid, I helped a borrower receive relief or a disability discharge on a private student loan because she'd become disabled after she had, gone to school, but her mom was still on the hook, right? So that didn't actually discharge the cosigner, who was the parent. And so one of the other ways that states can, strengthen protections is to strengthen cosigners laws, that ensure that additional evidence needs to be shown that somebody actually signed and intended to sign to be a cosigner. But yes, that's one of the ways in which this impacts older borrowers in particular, is when they come in as cosigners on some of these private student loans. Many private student loans require a credit check, and so they require a cosigner. If folks did not realize that they were cosigning for a loan, under many state laws about identity theft, that may actually be a defense to the debt. And so I would encourage cosigners who didn't realize that they actually signed on, that they could, potentially seek assistance through legal aid or something like that to assert as a defense to the debt that they did not intend to co-sign on that.
And I'll just add, in a related note, if the co-signer is a non-English speaker, they may be able to show that they just didn't have adequate understanding of what they were being asked to sign if they weren't provided a translation, but that often depends on state law.
That's a good point.
But I'll jump into, I think I mentioned it earlier, but Colorado, as part of our Student Loan Equity Act, did establish some protections for cosigners related to information that they need to get and how to release a cosigner eventually. So there are state law protections. And then I think there was a question sort of related to state law and sort of which ombudsperson you turn to. And it without speaking for other states, for Colorado, if you live in Colorado and you've told your servicer, for example, that that's your address, then you can come to us. We'll also try to help you even if you don't live in Colorado, but some of our tools might be somewhat more limited. And I think in the chat there is information on all of the states that have student loan ombudspersons or advocates. You can also, everyone can complain to the Consumer Financial Protection Bureau and get a response from their servicer or the collection agency through that mechanism. And those you can decide whether or not you want to include your complaint in the public database, which then becomes data that the rest of us can rely on as well.
Great, thank you. Maybe we should turn to talk a little bit about whether or not people have examples of successes, whether or not there's been any places where there's been some sort of incremental change or anything that perhaps was surprising as a way that did make life better for borrowers. If there's anything in any particular state or even at a local level, particular universities. I see you nodding, Kat. Do you want to jump in there?
Yeah, I was going to jump in. I know we'll leave. I guess since we're talking about surprising ones, I was going to say one thing that's really interesting this year, Martha. I guess to start, just piggybacking off what Martha was saying earlier about really just the importance of states taking action now. Again, we have a friendly administration, but it's really important for states to continue to act these bills. So we actually continue to have really this groundswell of like state protections across the country for student loan borrowers. But we actually surprisingly got wins in Louisiana this year. So I know we've mentioned a lot of different states, but also even thinking about places where we might not think that these protections might be as politically salient. We saw not only a student loan registry, but a borrower bill of rights. So not only creating greater transparency in a market where there's where we kind of like don't know as much, so actually being able to see like who's operating the state and what's going on there. But then two, again, talking about these common sense protections we were talking about in a borrower bill of rights. And one thing that's really powerful in states where we generally wouldn't expect these wins is how important that is then going to other places and seeing what is politically feasible, what's possible, and thinking about how can we continue to create these protections and continue to build upon what we already have. And then also I think Meredith, you spoke to something really powerful too. In addition, beyond states, even where we didn't necessarily see state legislators act, it was actually amazing to see where some schools actually took matters into their own hands, especially during COVID. And we're talking about institutional debt. Early on, we saw a lot of HBCUs really thinking creatively and taking these federal funds that they had because of COVID and actually using those to then again, pay off students into institutional debt. And so again, both, the money went back to them, but also again, taking these balances off students, off the students' sheet. So again, students were able to re-enroll if they needed to. If they needed to transfer to other schools, they could do so, or if there was any sort of like graduation hold. And so also really amazing to see not only HBCUs, but some community colleges, the city, University of New York, that system really seeing how those actions by schools actually also help propel some of the action that we saw later in the legislators after those actions during this past year.
Jith or Martha or Claire, you guys want to jump in on any possible successes, things that have worked?
Well, not to step on Jith's toes, he's from the legislature, but California has done a wonderful job passing a number of bills that are really humane when it comes to debt collection using the arm of the courts to protect lower income judgment debtors. And so California passed a bill called SB 616 a couple of years ago that says the first $1,700 pretty much in everyone's bank account, and then adjusts every year. But basically the first $1,700 in everyone's bank account is automatically exempt. So rather than put the burden on somebody to go to court to be like, hey, please don't take this, this is all the money I have, that there's a floor there that basically might allow somebody to still pay their rent, even if other money was taken out of their bank account. California also passed a law that said a creditor can no longer sell somebody's house for a judgment lien for a debt like this. So after you get a judgment entered against you, the creditor can put a lien on your house. But in California, the creditor can no longer force the sale of your home just because you have an outstanding debt. So again, California has taken a number of steps in the right direction. This year, there is a pending bill that would halt renewals of judgments, like I mentioned, but unfortunately, it might not capture a lot of student loan debt because it has a $50,000 cap on consumer debt with an exception for medical debt up to $200,000. And so one of the things that legislators could consider when making these sort of crafting this kind of legislation is to ensure that student loan debt at the higher amounts are looped into some of these protections, because our evidence shows from the data and the research that these student loan debts are generally significantly more than $50,000 when they get reduced to judgment, in part because of the accrual of interest over the years that they've been in delinquency.
I just want to point out, I think Claire's bringing up the amounts of these debts are just staggering. Like paying off more than $50,000 is unfathomable to most people, especially given all the other expenses that they have in their lives. And I think it goes to show that, well, I think Claire used a good word, humane. We can make collection fair, we can make it more humane, we can make it more, we've required servicers to be more responsive to people's debts. At the end of the day, there is just this enormous chunk of debt that many people have, and I certainly don't have a good answer for what
And with the judgments being renewable and continuing, so a debt doesn't show up on your credit report after 7 years after you stop paying, right? And actually, reporting judgment debts, so entries of judgment. However, if somebody wants to buy a home, for example, the mortgage servicer or the mortgage lender rather is going to do a much deeper credit check, and it's going to turn up those judgments. And so, so these debts that are interminable, that are renewable, these sit around and impede people's ability to become economically stable and really participate in the credit economy in a lot of ways. So we try to encourage first-time home buyer programs and things like that. Judgment debts for old student loan debts. And as Jeth just mentioned, if you've got a debt that's over $50,000 and it's accruing interest at 8, 9, 10% a year, I mean, that's something that you're never really going to be able to pay off as somebody on a moderate income. And so really putting an expiration date on old judgments, the data really shows that when these writs of execution get sent out, that's what a court sends to your bank account or sends to your employer. Many of those are returned not payable. They're not satisfied. The creditor's not actually getting any money back. And that just goes to show that the people who couldn't pay their student loan debts in the first place are certainly not in any better position to pay them after those debts have been reduced to judgment. So really, I mean, an expiration date or a carve out on wage garnishment and bank levies and things like that for private student loans would go a long way towards providing some relief for borrowers whose debts, whose student loans were very far in the past.
I want to turn for a few minutes to the issue of institutional debt, which Kat has raised, which basically is just money that a student owes to a college or university for unpaid fees. It could be library fees, parking fees, or unpaid tuition bills. And as Kat was mentioning, it can stop you from re-enrolling in school, and then you're unable to get the degree that would allow you to pay off your debt. But my understanding is also that states hire debt collection agencies to go after some of these students, and in some cases also sue them. And I'm wondering, the state, higher ed system would say, hey, we're working on a shoestring budget here. We need to have these debts repaid to us. But meanwhile, students don't have the money to pay. And I wondered if you all could talk about that and if there's any solutions to that problem when students owe money to their public colleges and universities. Who wants to start? Martha, how about you?
I don't have a lot to add other than what's already been said, is that our legislature has addressed this issue in the most recent legislative session. And so, the bill, it's framed sort of as you may withhold a transcript or words of homework except in these circumstances. And then there's a delineation of fairly broad circumstances where a student, if they need it for employment or for re-enrollment or transfer or things like that. So our legislature has already taken a position on that issue.
But maybe this is for anyone, but even if they're not withholding the transcript, they can still go after the student for the debt. Is that right? They can send a debt collection agency or they can sue them. Kat, I see you nodding there.
I was going to say they can, but one quick note I was going to make just kind of at the beginning about even the arguments that schools make about, they need this money. Schools actually don't collect much money off of transcript withholding. It's really just cents on a dollar. And so rather than the greater benefit, again, of not trying to, again, take money from students when you already know they don't have it. If they can't pay the debt, sending them to collections is not going to make that any better. Again, it's just a deeply punitive system. And so rather than creating a system where students can get their transcripts, their diplomas, so they can either re-enroll in another school, but so schools would actually probably see more benefit from allowing people to re-enroll and having students who might actually leave the system entirely rather than just, again, trying to chase these debts that students clearly can't afford because they don't have the means to pay them. So I just at least want to debunk that part about schools actually getting money from these debts, because again, they already aren't. And so they might benefit more from re-enrollment, students actually being able to get employment, but just wanted to put that pin in there.
I know one of the things, Claire, before we move to you, is that some states will cap the interest rates that debt collectors can charge. But in a place like California, I think the debt collection agencies are allowed to charge 35, 40%. I know in New York, CUNY, they can charge 30% on the debt. And I'm wondering, is there a legislative fix to that? Or is that something that's up to a state university system? Or is there any way to change? Because some of the students, what they would say is, I could pay the principal, I can't pay the interest.
Well, in California, up to the point of judgment, a creditor is allowed to charge the contract interest rate. And then and if they don't have a contract, then they're supposed to charge the statutory interest rate, which is 10%. And after the judgment is entered, that's 10%. So you're correct that if an institutional lender or an institution is collecting on its own debt or has assigned it to a debt collector for the purposes of collection prior to entry of judgment, that can continue to accrue interest at relatively high rates. We looked in the data in California, at least, we didn't see a whole lot of institutions suing under their own names, but that doesn't, I know that the Student Loan Law Institute at the University of California, Irvine was looking into this. And I think that they found that there was assignment to debt collectors who called and harassed and, dunned borrowers and students to get them to pay. And so one of the things we haven't touched on a whole lot is sort of that psychological burden of getting the phone calls and the letters and things like that by the creditors, and particularly when that's coming from the institution, the educational institution itself, with that threat of withholding a transcript, withholding a diploma, withholding transfer credits and things like that. I think that really puts a huge psychological burden on the borrower.
Jith, do you want to chime in on this?
So I'll just say that this hasn't been enough of an issue in California to come to my committee's attention. We have a higher education committee that may have dealt with the transcript withholding issue. The other aspect is that in California, like, the tuition is at most public universities is dwarfed by the housing costs. And I think that changes the mix of loans that a borrower may be taking from the institution versus federal loans in order to afford getting an apartment off campus or whatever they need to do in that regard.
Okay. Claire, there is a question about credit reporting that I'm hoping you can both explain and then what that question is, and then answer that.
Sure. So there's a question in the Q&A that says credit report related question. Someone asks, if the student debts have come off the credit report, does that mean that they've been forgiven or just given to a different entity, and how to go about finding out that information? So a credit reporting agency under the Federal Fair Credit Reporting Act is allowed to report debts that are in good standing kind of indefinitely. So if we're talking about federal student loans or private student loans, if those are in deferral, if they're in forbearance, if they're in an income-based repayment, even if that IBR repayment plan is zero, the credit reporting agency will continue to report that debt month after month, year after year. Once a debt becomes delinquent, right, the credit reporting agency must report it as 30, 60, or 90 days late. And then generally, after a private creditor, after 180 days, that debt will be what's called charged off. Charged off doesn't mean you don't owe it anymore, but what it does mean is that is considered a bad debt, a delinquent debt. So 7 years after sort of that charge off date, a credit reporting agency is not allowed to report your delinquent debt any longer. So that generally is 7 years and 180 days from when you stopped paying on the thing. And small payments on an old debt, even if the creditor calls you up and says, hey, give me a $125 payment, Well, that will reset their right to sue you. That doesn't reset the credit reporting timeline. There's only a debt only goes bad like one time. And so really it's 7 years from when you stopped paying on that debt. It will stop being reported on your credit report, regardless of whether or not it's been sold to another creditor, regardless of anything else. So even if it's sold to a new creditor, that creditor cannot newly report it on your credit report unless it's within that 7-year period. So in answer to the attendee's question, if a debt disappeared off your credit report, if it's a federal student loan, you should get online with your servicer and see if your servicer shows that the debts have been forgiven. So contact your servicer for your federal student loan. For private student loans, it doesn't mean that the debt has necessarily been forgiven. But what it might mean is that if it's been more than 4, 6, 10 years, whatever the statute of limitations is in your own state, it might be too old for them to sue you. So I would suggest checking up for private student loans to see how old a debt needs to be before the right to sue expires. Again, that's called the statute of limitations. And if nobody sued you and that time has expired, then that means that debt is too old for them to collect on anymore using the court system. And that means if they do send you a letter or call you up and say, hey, pay us, you should say, well, no, that debt's too old. I know you can't sue me in court. I'm not going to make a payment on that debt. So I hope that helps a little bit. What it means if a debt disappears off your credit report, it doesn't necessarily mean anything legally, because credit reporting is governed by a different statute than the debt collection process in the courts. But if you got so do look up the statute of limitations in your own state and then compare that to how long ago you made your last payment, and see if you're free and clear from that private student loan.
Great, thank you, Claire. That was very clearly explained. I appreciate that. So we're going to turn to audience questions now. We have about 20 minutes for that, and we'll start off with a question, Jith, that I think you're going to be able to answer, which was, since loan rules and laws are by state, is it the state you were in when the loans were taken out, or is it the laws where in the state that you currently live?
Yeah, so there's several stages in the life of a student loan, particularly a student loan that's gone to collection. And I'm talking about private student loans here. So when you when you borrow the money for a private student loan, the contract or the promissory note that you sign is going to specify that it is under the laws of a particular state. And that's going to govern things like the maximum interest rate that can be charged, what the statute of limitations is in many instances, and that state's laws are going to govern up to the point when you start missing payments and then your loan goes into collections. At that point, it's going to be governed both by federal law, which governs the Fair Credit Reporting Act and the Fair Debt Collection Practices Act, as well as the laws of the state that you're residing in. So there may be additional protections governing debt collection. And when you're sued, it's going to be under procedures of the state that you're living in. So if you're in California, if you're in Colorado, you will get the protections that I or Martha have been speaking about, even if your loan was made under the laws of another state when you first entered into it.
Great, thank you. I misspoke. We actually have almost a half an hour for questions, so please do keep them coming. Please know that some of the ones that are very specific and individual, we may not be able to answer in this panel, but hopefully some of the resources that are in the chat and back in the Q&A answers will be helpful for individual questions. The first one is, what do the panelists think about the possibility of states buying and canceling defaulted loans? Let's start with Kat. How about you?
I mean, I think everyone knows my answer would be, I would be proud of me talking about a fresh start. But again, I think we were talking about the benefits when, again, giving student loan borrowers that opportunity for a fresh start to be out of default. So I think my easy answer would be yes, but I would, would love to see other thoughts.
Does anyone have any thoughts on that? Is it a good idea? Bad idea? Is it a possible idea?
I mean, as Jith mentioned previously, the balances on these private student loans are pretty outrageous. And so I'll let maybe Martha chime in, from a state enforcement agency. But I do think that the state enforcement agencies can also use the power of litigation and the power of enforcement in order to potentially, seek non-enforceability on some of those old judgments. For example, again, I mentioned National Collegiate Student Loan Trust, which was the holder, which is basically a security instrument that like investors could invest in, that was constructed of a whole bunch, millions of dollars of private student loans. And there were a number of these different trusts. And so state AGs in New York and Massachusetts have brought actions against National Collegiate Student Loan Trust and their servicer, which is called Transworld or NCO Financial, for basically like lying on the witness stand and robo-signing and doing a whole bunch of these practices that were unfair and deceptive in obtaining judgments. So one of the things I think, that might be cheaper for a state to do is to use its enforcement capacity and enforcement capability to say, hey, you're a bad actor who's acting in predatory ways against the residents of this state. And so maybe we're going to get a holding and a determination from a court that some of these old judgments are not necessarily enforceable. And that might be sort of a more cost-effective way of proceeding against some of these bad actors who are trying to collect against against residents of the state. And of course, I'll let Martha chime in to see if that sounds reasonable.
Yeah, thanks, Claire. And I can think of a couple of examples where states have been doing that as well. I mean, it was part of the state's Navient settlement for some extent of student loan, of private education loan forgiveness. And there are some other enforcement actions that our office and other state AG's offices have taken where private education loan forgiveness has been part of it, particularly where a school is shutting down and maybe, working through that shutdown process. The other avenue, I think that's really a powerful one for state attorneys general and for individual borrowers as well is on the federal side is seeking a borrower defense to repayment. And I'll just celebrate the win because I think this came up in a prior panel as well, but it is important to celebrate the wins that today the Department of Education announced borrower defense discharge for ITT borrowers, and our office, along with the Oregon AG's office, helped lead the borrower defense application for the state AGs that was part of what the department relied on to discharge those loans. I would just highlight that it's really important that this is an automatic discharge. This is a group process. Borrowers do not have to apply for it. And so, in keeping with some of the themes that have come out throughout the whole panel series, thinking about how states can play a role in making sure that whether it's discharge or forgiveness or any of these things can be automatic, so that particularly the most vulnerable borrowers, it's not put on them to raise a hand to navigate these bureaucratic processes, but to really be able to make sure that the entities who have the information already are the ones who make sure that forgiveness happens. So I think it's always good to celebrate a win, and we're really proud of the work that we've done there.
Great. Here is another question. My new lender, this person transferred from Navient, has a bunch of incorrect information in my file, including the name of this person's college. Can I demand to see promissory notes and payment history to ensure that their records are accurate? What rights do borrowers really have in this arena? Any hands up to answer that one?
I mean, certainly in California, we have a student borrower Bill of Rights, and you would be able to demand a lot of information. The links that Suzanne Martindale provided at the outset would provide you information on those.
That pretty much Any other answers on that?
Yeah, without knowing specifics, I would be a little hesitant to give advice. But I would say that in a lot of these student loan borrower bill of rights bills, there is a mechanism for a qualified request, and there are timelines that servicers are supposed to follow to get that information. And also, just again, a plug for your state student loan ombudsperson, who can often help navigate getting information from a servicer.
Great. Please do keep questions coming because we will try to get to as many of them as we can. There was a question about private loans having expired and being able to then go back to the same creditor. If you all could address the issue of what does that mean? I'm not sure exactly what it means when a private loan expires, but if you all know what that means and could address what the person's rights are after that, if their private loans have expired.
There's a couple of ways that a private student loan can expire. And so Jith and I mentioned previously the statute of limitations. So a statute of limitations is a state law that's basically the right of the creditor to sue you in court. And that's limited, depending on where you live, to a certain period of time. And usually it's a certain number of years from your last payment, although that might differ a little bit state by state. In California, if you've gone beyond that 4-year limit, a creditor can still sue you, but only if you indicate in writing that you want to reaffirm the debt. And so that, of course, can differ state by state, whether or not you can wake up a zombie debt after it's expired by making another payment, right? But in general, you want to avoid making payments on old debts because it's better to let that statute of limitations run. And so they can't sue you in court. So that's one way that a debt can expire. Another way that a private student loan debt or a private debt can expire is if it's discharged in a bankruptcy. So if you go to court, and to bankruptcy court and you obtain a bankruptcy discharge, in general, private student loans and federal student loans are exempted from that discharge unless you specifically ask the bankruptcy court in what's called an adversary proceeding to make a determination that your loans are discharged. So if your private student loans are discharged in bankruptcy, that's another way in which that the debt could have been expired, right? Basically, it would be discharged in a bankruptcy. Creditors are allowed, however, to make their own determinations as to creditworthiness. And so I've certainly seen creditors refuse to issue credit to a borrower after they had filed for a bankruptcy because they discharged a debt to that particular creditor. So creditors are supposed to take into account your creditworthiness in general, but you may want to seek credit from a different lender after if you have defaulted and the statute of limitations has run on a private student loan. Again, I think one of the takeaways that I'm not sure anybody has said explicitly is that private student loans are generally not an incredibly good investment, right? Private student loans tend to carry a high interest rate. They tend to not have the protection of federal student loans. So if the attendee's question was, where should I go for a private student loan? I think the panelists sort of in general would encourage the borrower to look at their federal student loan options and their other options for financing their education rather than look to a private student loan lender.
Great. Jith, do you want to jump in there?
This may be more of a question for Claire or for Martha, but if I recall from when I was practicing, there were complications with the statute of limitations if there was a promissory note, because under some states' laws, each payment that came due carried its own statute of limitations. So in situations like that, it may not just be 4 years, 5 years, 6 years, what have you, from the first time you missed a payment. It may be that every payment carries with it that statute of limitations. So it's important to be careful on this.
Martha, sorry, do you want to jump in there too?
Yeah, I think I would. That's probably advice best given to an individual and their attorney. But I think a really good flag that the statute of limitations issues can be really complicated, and it's important to if you have access to an attorney to have them sort those through. I just wanted to jump in briefly on the bankruptcy point that Claire was making, just to highlight some work that our office did. Attorney General Weiser did send a letter this spring to our U.S. attorney here in the District of Colorado, urging him to consider how the undue hardship standard is applied by his office, and how to consider how to make sure that borrowers really are able to get the fresh start that is enshrined in the bankruptcy law. So, and I know that the Department of Education has made some statements and is working with the Department of Justice, who represents them in these bankruptcy proceedings. But I think that's also an opportunity where advocacy is really important, that the Department of Education and the Department of Justice have the ability to decide whether or not to pursue these adversarial proceedings and pursue borrowers who really may be in quite dire circumstances, and it would be appropriate to discharge their loans through bankruptcy.
Great, thank you. Kat, if you want to try this one, there's a question about income-driven repayment, the IDR. And the question is, how can you get your federal student loans wiped after 20 years? Does it matter if you have not made any payments toward the loan due to a lack of resources? That is a loan that's not in default.
Okay, so we're going to answer that in two parts. The first one, just to clarify, so someone said they haven't made payments because of lack of resources, but they're not in default, so they may be on a $0 IDR plan. So if that's the case, I'm just going to kind of assume that scenario. But also I'm going to talk a little bit about the Department of Education's income-driven repayment account adjustment. And so earlier in Suzanne's opening remarks, she talked a bit about how we have a broken student loan system that hasn't lived up to its promises. And so part of the Biden administration's plan to fix this broken student loan system was in April looking at one set of the student loan system that has not worked the way that it should, and that's the income-driven repayment plan program. And so under income-driven repayment, depending on which payment plan you're in, you should get debt cancellation after 20 or 25 years in repayment. But what we've seen is that's not the case. So very few borrowers, I think at this point, and Persis can correct me on the numbers, but I believe less than 200 people have actually gotten cancellation under this program through the duration of its history. So in order to correct this, the Department of Education is going to do a one-time payment count adjustment where they'll give people credit for any month when they're in active repayment status. And so that means as long as the borrower wasn't in default. And then also the Department of Education is going to count certain periods of deferment or forbearance. So that means for 12 months where someone was in consecutive forbearance, and part of this is to address the idea that servicers, rather than helping enroll people in affordable IDR plans, were steering people towards forbearance where they weren't actually getting credit towards cancellation. The department will count those 12 or more consecutive months towards repayment. People will also get credit where they had 36 or more cumulative months of forbearance, again, to address those forbearance steering issues. And then again, for any time in forbearance prior to 2013, with the exception of in-school deferment, borrowers will get credit for those period of time. Also, one thing that's really important to note is that two things: for people who have additional periods of forbearance and deferment, you can file specific complaints with the Department of Education, so Federal Student Aid's ombudsperson to say, I was steered into forbearance, I was steered into deferment. And so if you're under that 12 consecutive months, under that 36 cumulative months, you can actually file a complaint and explain why those other periods of deferment or forbearance should be counted, particularly for people who have older loans. So people who have FFEL loans, Perkins loans, loans that predate the direct loan program in 2010. In order to take advantage of this waiver, to take advantage of this account adjustment, you'll have to consolidate your loans into a direct loan. So that actually is a really important step. I think I mentioned earlier, the difficulty of getting this, the department's doing these things to help people get additional credit towards debt cancellation, but people have to know about it. So one thing that we are going to do at the Student Borrower Protection Center, we will have additional resources specifically for this IDR account adjustment. And so we'll be sure to share those out once we have that. But just wanted to talk a little bit about that as one pathway that people have to debt cancellation. So thanks for that question.
Great, thank you. There is a question that I will read out while we're waiting for Jith to come back there. If someone has a mortgage, a car note, private student loans that have been paid, how is that to be put on a high repayment plan under any of the income-driven plans? Is there anything this person says I should do or say so that my provider considers my expenses? So I know you can't provide individual specific advice there, but I think they're asking about to what extent the expenses can be part of what's considered. And I don't know who's best to answer that. So I'll just need a hand up.
Yeah, I think Persis, or maybe that was just us, maybe not in the chat, but unfortunately the IDR formulas are pretty set, and it's based on family size and income. So if you think that your servicer isn't calculating it correctly, that would be one issue, but just trying to get a different calculation without knowing particular circumstances, but generally it's a pretty rigid formula, and so it's not going to take into account expenses.
Great, thank you. Jith, if you could talk about the private rights of action and why that's important for the legislatures to include, and explain what a private right of action is before you explain its importance.
Yeah, great question. So a private right of action is essentially a statute that enables or facilitates a private attorney representing a person that's harmed in litigation. And there's sort of a spectrum. So at the most basic level, it could say that a person can sue for a violation of the statute. But that standing alone doesn't do a whole lot, since most people don't have the money to pay for an attorney on an hourly basis, certainly people who are already struggling financially. So usually a private right of action also includes what's known as a fee shifting provision. So if you win your case, your attorney gets paid their fees and their costs, and so they have an incentive to take your case. So even in famously progressive California, this tends to be the most highly contested part of any piece of legislation that we pass, because student loan servicers, lenders, debt collectors don't like being sued, and they would prefer that enforcement be entirely by state attorneys general or by agencies like our Department of Financial Protection and Innovation. Obviously, there are far fewer attorneys at those agencies, so there's less enforcement. So the private right of action essentially harnesses private attorneys in enforcing borrowers' rights, and often means that more people are able to get legal assistance.
Great, thank you. Here's another question. I attended Walden University, one of the for-profit colleges under scrutiny right now. What can I do to get the loans forgiven from that college? And more generally, what can students and borrowers do if they feel like they've been harmed by their school? Claire, do you want to start?
Well, so for federal student loans, I think I'll defer to the experts on the federal student loan program and the borrower's defense to repayment. But I do know that the borrower's defense to repayment, the Department of Education is moving forward on attempting to grant relief for a number, like on a mass basis, for people who have attended particular universities. I personally don't know exactly where Walden falls into that, and so maybe I'll defer to somebody who works a little bit more on the federal student loan side to speak to that. With regard to private student loans, if you have private student loans, as other folks have mentioned, there may be opportunities within your state. Your state may be providing some relief for closed schools or schools where there's been a finding of malfeasance or wrongdoing, where schools were stripped of their accreditation. Again, I can't speak to this particular university, but I do know that some states, including California, have provided, some reimbursement funds for private student loans when there is otherwise like a closed school discharge available on the federal student loan side. So again, I would look to see what your state AG's office is doing, what your state ombudsman person is doing, and also follow up with the Department of Education and the CFPB with regard to that particular university and the borrower's defense to repayment status.
Great, thank you, Claire, and thank you for all those questions from the audience. Really appreciate everybody tuning in and asking such interesting questions. We're going to just give all the panelists the chance to share their closing thoughts before we end the panel. So Martha, we can start with you if there's anything that you want to say to wrap up, or any additional things that you've been thinking about throughout the panel.
Yeah, thank you so much. And thank you so much to the SBPC for hosting. And I just continuing on with my theme for entrenching these authorities within the states. I did just want to highlight on the federal collection side that there's been a lot of work and advocacy on making sure that states have the authority over third-party contractors of the Department of Education, and to make sure that states have that authority and that authority is recognized. So our office sued FIA a little over a year ago when they refused to comply with our examination authority. The Department of Education in 2018 had issued a preemption notice that was rejected by many courts along the way, and the Department of Education subsequently has revised that preemption notice and taken the position that states generally have authorities over their contractors. That went out for comment and has not yet been finalized. But states also have authorities under the Dodd-Frank Act to enforce federal law. So I think building up the capacity in states to be protecting borrowers in these circumstances is a really important advocacy. It's important advocacy work, and as Suzanne said, then there are dedicated public servants in the states who can continue with this work for years to come. So thanks so much for having me.
Great, thank you. Kat, do you want to go ahead?
I will also just extend another round of thanks and just say it's wonderful to be on this amazing panel with all my fellow panelists, and also Meredith, you as a moderator. But I love what Martha was saying about, again, the power of states really to create additional rules and accountability mechanisms to protect borrowers. And so I won't go there, because I think you stated that so wonderfully. But one thing I will add is just really thinking about the fact that we really can think about really creative solutions to really reform what is a deeply punitive system. Again, I said, while I don't believe in the debt collection system, but thinking about creative ways. And the reason why I really think, especially institutional debt is one really powerful example. It's just, this was such a longstanding practice that seems so deeply a part of university systems. And I think during the pandemic, we really just started seeing people say, this is deeply unjust. It doesn't make sense. And really thinking about ways that, one, individual schools found ways to take action, and then where they wouldn't, really seeing advocates and legislators really pushing pushing schools to take these steps to like not penalize their students for not having the means to be able to pay the debt. And so that's something I think I just really want to emphasize, is that we don't have to live with this deeply flawed system, and we really are seeing the way that we really are changing the student loan system. So really just continue to push and advocate for that fight.
Great, thank you. Claire, do you want to go ahead?
Well, I just want to thank everybody for the opportunity to be here today and for this really wonderful conversation, including all the questions from the attendees. I thought that they were excellent questions, and they showed really that borrowers are engaged, right? And you also see that throughout like the SBPC's social media presence, like borrowers are engaged, whether or not they're in default yet, or they're just struggling to make payments. People are fed up with a system that doesn't work. And so I would just encourage, folks out there to continue making a bunch of noise. It's really exciting to have this conversation about what states can do, because as I think one of my fellow panelists mentioned earlier, like appointments matter, right? Elections matter. And so we saw in the previous presidential administration, we saw a real disengagement from borrowers' rights in federal agencies, across the board. And so it's really important that states can step up and maintain sort of that consistency, regardless of what's going on at the federal level, in order to protect the borrowers in their states. So I would like to encourage, everybody who's attended on this call to continue to remain engaged, to continue to make noise at the state level, to let your state representatives, your AG's office know that these are really issues that are important to you.
Great, thank you. And Jith.
I'll begin by echoing everyone else and saying thank you to SBPC for inviting me, and Meredith for doing a great job at moderating, and my co-panelists. I think there's been a really great array of information here. I guess two closing thoughts. One, for those of you who are watching who are involved in policy, I think one advantage you have at the state level is that increasing numbers of legislative staff and legislators themselves carry student loan debt. I think they're going to have some empathy for these issues, and yeah, I think there are openings for reform in many legislatures because of that. Second, for those of you who had individual questions, I think it was a message was dropped in the chat, but National Association of Consumer Advocates, NACA, has a searchable database of consumer attorneys who work on various issues, and you could look for attorneys in your state who work on student loan issues so that you can get perhaps particular advice about your situation. So thank you all.
Thanks so much, and thank you to all of you guys for your incredible amount of knowledge and sharing it. I learned a lot just listening to you all, and thank you to the SBPC for inviting me. I really appreciate it, and I'll turn it over to you, Persis.
Thank you so much, Meredith. Thank you so much to our panelists for sharing that wealth of information, and more importantly, for the advocacy that you do every single day on behalf of student loan borrowers. And to our audience, thank you so much for staying engaged on an issue of state debt collection for 2 hours, talking about these very technical issues. But I think, what I think it shows is, I like the way that it was just said in those summations, like borrowers are fed up, right? And Claire said borrowers are fed up. And as Kat mentioned, we don't have to live with this punitive system anymore. And so I think there really is a window, but I appreciate that everybody lifting up the experiences of defaulted student loan borrowers, both on the federal and the state level over the last couple of weeks. I think this is an issue that is long overdue the attention that it needs. And so thank you all for participating. Thank you so much to our panelists and to Meredith for shepherding us through this conversation. I hope that you enjoyed it, and I hope you all have a lovely rest of your afternoon or morning. Take care. Bye, everyone.